Hi everyone, I'm Sabrina.
And I'm Jonathan, and we are the lawyers at Verity Law.
Today, we're going to talk about when a buyer or a seller to a real estate property decides to breach the contract.
Yes, this means that either they did not fulfill a binding term of the contract, or they decided to back out of the contract altogether before closing. Unfortunately, this does happen a lot.
Why is that?
Because the contract, more commonly referred to as the offer, is not reviewed by a lawyer before it's signed by both parties. The usual procedure is that one or more realtors prepare the offer based on the ORIA form, and then the buyer and seller review it themselves and sign it.
Yes, unless the realtor adds a solicitor review condition on the contract. This means that even after signing the contract, either side can get a lawyer to review the contract and back out of the agreement if there is something legally wrong with it.
But do be careful here. The solicitor review condition does not mean that you can back out for any non-legal reasons. The lawyer must be able to find a valid legal problem with the agreement. For instance, if the contract did not guarantee that there's no litigation relating to the property, then the lawyer can insist on adding it in. If the other side disagrees with that clause, then you can back out of the contract.
In contrast, if there is nothing legally wrong with the agreement, then you cannot use the solicitor review condition to back out. Let's say you decided you no longer like the color and shape of the windows. You cannot back out because of this non-legal reason.
Exactly. It must be an issue relating to the ownership or legality of the property.
Okay, moving on. So what happens if a party refuses to follow all the terms of the agreement?
First, we must separate the terms from the conditions. A condition is usually a reason that allows either party to back out of the contract, no problem. Conditions are often added by realtors at the end of the offer.
Yes. Common conditions include financing condition, meaning that the buyer must first get mortgage approval before they purchase the property. If the buyer fails to get mortgage approval, then they can back out of the contract.
How would the sellers know if the buyers actually succeeded or failed to get that mortgage?
Well, they just gotta take the buyer's word for it. They cannot go around asking mortgage lenders themselves.
That makes sense. Now, another common condition is the property inspection condition. The buyer may hire a professional company to inspect the property and note any damages. If there are damages, the buyer can choose to accept it, ask the seller to make repairs before closing, or back out of the contract.
Precisely. Because most conditions allow you to back out of the contract, offers with conditions is considered a non-binding contract. Only after all the conditions are waived is an offer considered firm and ready to proceed.
During the process of waiting for conditions to be removed, the seller cannot accept other new offers without conditions.
Okay, moving on to breaches. There are two types of breaches, fundamental breaches and minor breaches.
Now, only in the case of fundamental breaches by the seller can the buyer back out of the deal. In those cases, most judges would agree the signed offer is terminated due to the breach.
So what are considered fundamental breaches?
Well, let me give you a few examples. First, if it's something affecting the ownership of the property, like debts or litigation registered on the property. Let's say when the seller first bought the house, they got a mortgage with TD Bank. Naturally, TD Bank would register the mortgage on title to the property. At closing, if the seller refuses to pay off or is unable to pay off the mortgage, then that's considered a fundamental breach.
Makes sense? Because it's a fundamental breach, the buyer can back out of the deal and get their deposit back. If the seller refuses to give back the deposit, the buyers can sue them in court.
Exactly. Another example is when the seller refuses to leave or vacate the property on closing. Obviously, when the purchasers buy a property, they expect to move into the property to live there or maybe to rent it out to others. The seller's refusing to leave is a fundamental breach.
Of course. As well, if the seller promises to make substantial renovations, as stated on the offer, but then at closing refuse to complete those renovations, then it's a fundamental breach. Substantial means big renovations, such as replacing a roof or completing an unfinished basement.
In contrast, minor renovations are considered minor breaches. The buyers are not allowed to terminate the offer based on minor breaches. Examples of minor renovations might include things like fixing a lock or doing some repainting.
Very true. Other examples of minor breaches include fixing the washing machine, cleaning up the property, and removing all garbage, or removing chattels like a playground equipment from the backyard.
Now, to require the sellers to fix those minor breaches, there must be corresponding conditions listed in the signed offer. For instance, if the buyer wants garbage to be removed, then the offer must specifically state that the seller has the obligation to remove all garbage before closing.
Yes, if the offer does not specifically say that, then the buyer cannot demand this. Another reason why the offer should be reviewed by an experienced lawyer before both parties sign is to ensure those clauses are actually included.
Now, the buyers do have to understand when it comes to many of the terms within the offer, the seller can either comply with the term or pay the money required. In the case of garbage removal, for example, the seller could either remove the garbage or they could pay money so that the buyer can hire a garbage removal company to remove the garbage themselves. The buyer cannot actually demand that the property is cleaned before they pay the seller.
So here we got to the important part, quantifying damages. In many cases, the sellers find it easier to pay for the damages than actually comply with the terms. Then the buyer must state exactly how much money they want in return. This amount cannot be pulled out of thin air and be unreasonable.
Right. The buyers must have a reasonable basis for asking for, let's say, $1,000 for garbage removal. The buyers could get a quote from a company like Just Junk, who can create a formal quote or invoice to remove the garbage left on the property.
Now, what happens if the seller refuses to remove the garbage and refuses to pay?
That is definitely not good. But because it is a minor breach, the buyer still cannot refuse to close based on this.
So what happens if the buyer just refuses to close?
Then the seller could sue for damages or sue for a court order to keep the buyer's deposit as compensation. In this case, although the seller breached the offer by not removing the garbage, the buyer also breached the offer by failing to close.
Exactly. And the seller made a minor breach, whereas the buyer made a major breach. So in the end, the buyer ends up paying more.
So what are some options for the buyer then?
Well, more commonly, for minor breaches, the buyer should request a holdback of money. So going back to the garbage removal example, the buyer, after getting a quote from Just Junk, can request to hold back $1,000 from the purchase price. Only when the seller removes the garbage, then the buyer will give the seller the $1,000 back.
Yes, of course, if the seller thinks the garbage removal is too troublesome to do themselves, they can also simply reduce the purchase price by $1,000.
Although holdbacks are common, they are not guaranteed. The best way to ensure a holdback is to put this clause in the offer. So instead of just saying the seller must remove all garbage, the realtor should change the clause to have a consequence. Something like the seller must remove all garbage or else the buyer is entitled to $1,000 holdback.
If there is no such clause in the offer, the seller and their lawyer could refuse the holdback. Then the buyer would need to first close the purchase to avoid a fundamental breach and losing their deposit. Then the buyer would need to spend more money to sue the sellers in small claims court.
Now, there is the extreme remedy of specific performance. This means that the court will actually force the seller into fulfilling the terms of the offer.
Yes, but this is very rare, and the court will definitely not force the seller to do something as minor as removing garbage. Only when money cannot compensate the buyer would the court award specific performance. This means that even if the buyer has money, they cannot fix what the seller broke.
An example is refusing to complete a sale of a truly unique property that cannot be switched to a different property. Let's say the buyer agreed to purchase their neighbor's property and then started a major renovation to expand their home onto the neighbor's property. Later, the seller neighbor changes their mind and refuses to complete the sale. Then, since the seller's property is the only property that will allow the buyer to complete their expansion, which they already started, the court could force the seller to complete the sale.
Yes, it is essential to keep in mind that the burden is on the buyer to prove that money cannot fix the contractual breach.
In conclusion, it is essential to have a real estate lawyer reviewing an offer before any real estate buyer and seller signs the agreement. An offer with valid conditions would allow the buyer or seller to legally back out of the contract. That's why a conditional offer is not considered binding or firm.
Now, a firm offer can still be breached by either party. A fundamental breach would allow either party to terminate the contract, refuse to close, and sue for damages. A minor breach would only allow the innocent party to ask for a reasonable price reduction, a holdback, or they could sue the breaching party in small claims court.
Only in very rare cases where money cannot compensate the innocent party would the court force the breaching party to follow the terms, like complete a sale. This is called specific performance.
The key to the story is that a buyer should not refuse to close a purchase, aka make a fundamental breach, when the seller refuses to remove garbage from the property or commits some other minor breach. Doing so would result in a much higher payment from the buyers.
All right, that's all for today. We will see you in our next month's video.